at is the Fair Credit Billing Act. And I like the Fair Credit Billing Act because you can ask for validation under the Fair Credit Billing Act, Fair Debt Collection Practices Act, and Fair Credit Reporting Act. And you ask them to validate the debt under all three.
All three?
All three of them at the same time. What happens is they have to provide the original, on the Fair Credit Billing Act, they have to provide the original copy of the original application that you signed. And because the actual contract did not come with the application, they have to provide you with the original terms of the agreement of the application that you signed. Okay, so if you signed it way back in '86 and you're asking for it now, they have to present you with the contract that you signed originally in '86.
They don't have it. Yep.
Well, there's another act that they forget about. The other act that they forget about is the Equal Opportunity Act. The Equal Opportunity Act states that they have to keep all information on everybody that applies for a loan for 25 months. So Bank of America keeps it for 48 months and then they destroy the applications and all the original documentation. Which means they don't have it. All they have is an electronic file and they don't have the hard copy that they're supposed to use to back up the debt.
So they can't try to prevent that in.
No, they have nothing to take to court.
I mean, they can't just print one out and that judge says that's good enough.
No, that's not evidence. A copy is not evidence, yes.
How many months did you say they have to keep it?
By law, they have to keep it 25 months. Bank of America keeps it the longest, it's just 48 months.
Aren't there some courts, though, that are allowing the electronic evidence to be admitted?
It depends on who is representing the evidence to the court. That comes into under ultra vires, who can testify for a corporation. There's only 4 people that can testify for a corporation: the vice president, president, CFO, and secretary. But the secretary that they always say is the one that writes the thing is not the secretary of the corporation. Or the person that reviews the file. If they review the file, it's not their file. So there's a lot of things that they don't do that they're supposed to do, that they don't do. And the main thing that they do is that because they don't do the validation, because the records are destroyed, they have nothing to bring to court. And they don't do it through an officer of the corporation, which means nobody can testify for the corporation. Who do they usually bring? You got an attorney on this side, and you got an attorney on this side. Nobody shows up. So if the attorney's sitting there talking, there's nothing going on the record. You could talk all day.
All day long.
And it'd be a void under the law of voids. So it's a combination between all these things that they don't do. And 90% of the time, even if they have a judgment signed, sealed, and delivered by the court, and if you, under the Fair Debt Collection Practice Act, state that I'd like you to validate this debt, and they have a judgment, okay, all they have to prove, they just have to show you the judgment. But they never do that. They just send it to Lucy or Sally over here, and they type it out on the computer, print it out, and guess what happens? You owe the debt, because I say you do right here. No proof. You owe it. Okay, if for instance, under the Fair Debt Collection Practices Act, you were to ask them to validate the debt, and they didn't, and they still just provided you a letter, it's not validation either way.
What is your definition of validation?
A validation goes under corporate law for a corporation. If it's a corporation, it has to go under the corporate bylaws of the corporation, which means there has to be minutes. The corporation has to tell you what it is that you owe the corporation. So the board has to convene. They have to put it down. They have to vote and say, this is, yes, he does owe us this amount of money. Then they have to issue the resolution. Then the resolution of the corporation has to have the seal placed on it. Then the resolution is issued with the seal. Then they send that to the court with a representative from the board saying, yes, you owe it.
And that is where that definition?
That definition, that's how corporate proceedings work. That's the law. When they put the seal on the corporate resolution, that's executing the resolution for the corporation, saying what the corporation says it's supposed to do, or what the person owes.
That's when you're making the loan, or,
No, that's when they ask to validate it. That's
To
the
validate.
that's the procedure that they should do if they're a corporation.
is that the procedure they use when they, because the credit union that we've gotten loans from, they say they're meeting on a certain time and they're going to vote on it. We don't know why they,
Because they're announcing publicly that they're a publicly traded company, and they're announcing that they're having a meeting so that people can show up to vote on it, to be a part of the proceedings. See, there's a difference between corporate law and sole proprietorship law. And then you got different types of structures of different companies, but they all fall under certain things. Now, for instance, a trust. A trust has to have bylaws. A trust also has to have minutes. If a trust does not have minutes or bylaws, it's not a trust.
right.
It's a fiction. Because there's no intent. It doesn't tell what the intent of the trust is or what they're doing. So the combinations of how those entities work together and how those entities sue a person, they have to abide by their rules to do it. And they take the simplest way. They send you a letter. And one of the funniest letters, and I've seen like 4 different versions of it, but it basically states, under the theory of quantum merit, you owe us $5,000. Please pay, or we'll have to sue. I never heard of these guys in my life.